Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live. Welcome, Kirk Pendergrass. How's it going? I think he's still working on his tablet. All right. Good to meet you too, John. I'm aware of you. I saw a lot of your posts on Chris's group, Amber and Steven. So I knew that you were out there and you were a thinker. You're trying to find solutions, like Kirk and Chris are, and you guys seem to be, mentally on the same page. So I'm glad you're a part of this clique with them, sharing your information. Yep. Yeah, some people have their volume down or they're not clicked on the show, and almost every single show you'll get somebody, and then they'll be like, "Oh, whoops, I didn't click on it." Like right now, I have my volume down. Yeah, some people have their volume down or they're not clicked on the show, and almost every single show you'll get somebody, and then they'll be like, "Oh, whoops, I didn't click on it." Like right now, I have my volume down. Yeah, some people have their volume down or they're not clicked on the show. Oh. And almost every single show Jesus Christ. Something is wrong. Like, oh, whoops, I didn't click on it. Like right now, I have my volume down. Okay, hold on. I'm working on it, guys. Yeah, some people have their volume down or they're not clicked on the show. Oh. And almost every single show you'll get somebody. Something is wrong. Like, oh, whoops, I didn't click on it. Like right now, well, these are... Okay, hold on. I'm working on it, guys. I need to turn this. I'm hearing an echo too. Okay.
something.
Testicle 1, 2.
1, 2, 3, 4, 5, 6, 7, 8. Oh, just kidding.
Testicle 1, 2.
1, 2, 3,
Okay.
4, 5, 6, 7, 8.
Audio is working. Testicle 1, 2.
Whoa, that's like times 3.
Okay. Audio is working.
Yeah, still an echo, Brian Lee says.
Somebody's got some audio either up too loud or too close to their microphone. I'm still doing some shares here. Trying to get it out.
Volume down, does that help?
Yeah, my audio's all the way down on my phone, so can't wrap my head around that one. Okay. All right. Wing it. Love it.
All right.
So,
Holy smokes, some people have added me to some new groups. What the heck?
right?
Just in the last week.
Well, we've had a busy weekend. If you're all wondering why Nate's not back yet, we are going to be doing a follow-up with him. We've had some serious activity in that case. So before we continue on with part 2, we want to see how that activity plays out. So just to let you know, Nathan Altenhofen is coming back to get us over the hump there. But for here and now, we're going to go ahead and proceed on and just go back to our regularly scheduled programming until we get the word back from the Texas Office of Inspector General. So that's kind of where we are with him. And where you at, Kirk? You back up and running there, buddy, or are you still sharing?
Yep, I think I'm good. I posted, I did a couple of quick shares. Hi, Rebecca, Lori, and Neely, Brian. Oh, Tammy Nichols watching. Thanks for tuning in.
Got
Where we
Rio
share
Brian.
the law.
We got Brian Lee. We got Lori Carr.
Teach what we teach. Jay.
Myers.
Tanya, of course.
Ryan Van Aken, Diane Lyons. Good to have all you guys back. Good to see everybody back up and running again.
Yeah, we had to take a small break there due to some personal paperwork and issues, and still dealing with that, but I think I'm over a hump there. So, and then Chris, he was buried in paperwork as well. So we have Ted Fogg, our producer, back with a new freshly built computer. So this is kind of first test run back together, and Ted went on vacation and his computer decided to burn up on him, so had to rebuild the computer. And let me tell you, I'm very grateful that he is back. Even though we managed to make it through, I figured out how to at least bare bones work the OBS. I like this better. So we're going to do some screen sharing and kind of show you some stuff. We love you, Ted. So yeah, Monday nights, regular just teaching the law type stuff, discussing e-clause stuff, and then Wednesdays is the call-in show. So you have questions and stuff, tune in on Wednesday nights.
Ah. Ah. Chat issues. That chat, is that through Zoom or is that through OBS? Oh. So yeah, they're the kids that don't play well with others.
Jennifer Wynn, she asks, are we attorneys? Well, I'm not. John's not. But Christopher Hallett
I got indoctrinated.
got his bar permission. Although his story is quite unique, and this is part of what we do here is e-clause. And I'll go ahead and let Chris explain what he did there, because that's his.
Well, basically, how this whole thing evolved is it evolved as a for-profit corporation for the simple reason that I had my particular issue, and I had a couple clients at the same time that were in more than one state. Now, because of the way the current practice is set up, there is no state-to-state mechanism other than federal. So I said, okay, well, I'm going to go through the Department of State, and we set this up so we could use the interstate commerce. So kind of like the way a franchise does business, like McDonald's or Walmart or Wendy's or whoever. We just went ahead and tagged onto that and just said, okay, we'll just use that for now. And I'll just go directly through to each state inspector general. So while I was doing the paperwork, setting up the corporation and submitted basically my company's mission statement, which was my judicial report, they decided to knight me as an esquire. Now, how that works, like I said, ask them. It's their shtick. It's Congress's deal. That's what they wanted. So, because loss prevention is, as far as I'm concerned, is so much more than just legal. Legal is like a very minuscule piece of what I do. And but anyway, that's the way they wanted it, and that's what that's how they addressed me, and they titled the documentation through the Department of State. And I think that was probably relative due to my suggestion about how we solve this problem through equalizing the practice of law. And that's, of course, all in my judicial report. And I think what they decided to do was use my corporation as a kind of a trial to see and so far so good. I've developed some pretty good relationships with some of the agencies out there and shown them the benefits of what I do. And it's just everything. It's not just litigation. It's policy and procedure review. It's budget review. It's pretty much helps them manage their department and offer support if needed. So, matter of fact, I was just at a policy meeting earlier today, and it went very well. We had some in-house counsel, the traditional bar members that weren't happy about it, especially when they found out that they're not going to be getting a chance to bill the taxpayers to do the work that I'm going to do as the spine, the support system for all the agencies. And they're saying, "Oh, that's practicing law." I said, "Well, you don't practice law either," which is one of the reasons we're having this conversation. So, as you can imagine, how well what that went over. But hey, they couldn't argue it because they know it's true. So, it is what it is. So that's kind of where we are now, and that's basically how E-Clause was built. And it was a petition through Congress. It's kind of big and bulky and clunky right now, but we're streamlining it. And once we get the thing that we like and get it set up the way we want it, then we can say, okay, we're going to go to DC or we're going to go wherever, and we're going to start teaching all the other states how to do it. But right now, believe it or not, as irony would have it, the first department to tag in and take part in the business plan is DCF. Probably only because of our couple of the cases are related to DCF, and that's where the records are. So if we're going to go back through and reverse that process and give the kids back, we got to go where the records are. So that's kind of how that evolved.
Yep, and boy, am I sure glad I came across you, and I'm sure glad that you've done what you've done. Because, for those of you that are new here tonight and don't know me personally or have been on here before, I've studied law, mostly criminal law and constitutional law, starting back clear in 1995. And then I got into start doing research on the history of our law, history of our nation, and, the law of creation and all that great stuff that's actually the foundation of law, fundamental principles of law, how a nation is created. So I'm very knowledgeable on history of our law, clear back to 1166 with the Aziz, which is originally where the right to a trial by jury comes from, where it originated. So, through there to the Magna Carta and several different revisions of the Magna Carta, 3 different revisions from there. And, John over here, he's an expert on the federal rules of civil procedure, and man, is he beating them up in the federal court over there. So we have, each one of us here has a different skill set and abilities, and some crossover into others, which is what makes us a great team right here. In all my readings of the Constitution, I always skimmed over that word emolument in Article 1, Section 9, Clause 8. I always focused on that title of nobility thing. But Chris, he decided to knock the dust off of that word. Nobody in our history has brought that to the attention of the courts and brought it in front of as an articles of impeachment or anything like that in 200 some years, 240 years. So, Chris did the unimaginable apparently. And given his background, working in loss prevention and real estate, he's got his fiduciary license to begin with, so he's already got his license to practice law. He said, all right, fine.
License to practice. It was a license to practice, and the thing was just isolated as a brokerage practice of real estate. And I said, okay, well, we're going to take that model. We're going to pull the real estate off of it, and we're going to staple loss prevention to it. And I'm going to show you what loss prevention is and how it mirrors the practice of law. So, and, it's funny because, when you want to solve a problem, the first thing you do is you show it to itself. You make it realize it's a problem. And that's when you start getting traction. I just did it a little differently than other people did. And I was just working on my case when I started this, just like the rest of y'all. So, only in America, right? So,
right. So I'm going to kind of just, I'm going to do a screen share here so you guys can get an idea how this works and kind of the stuff that I do. Google. All right, let's see if that pops up. It should pop up screen share here. There's a delay, so I'm waiting. Charles, he says, I was able to get every officer of the court in California disqualified from hearing any case about me based on bias created by undisclosed emoluments. Awesome. All right, so here's my screen, and up here you can see my quick links. And so my first one here is law.cornell.edu, and I have it set to go straight to the Constitution. When you come here, you might come to a different page if you go straight to law.cornell.edu. But you have to search around, click on the Constitution. Once you get there, here's Get the Law. Now, on this site, you have the Constitution, you got Supreme Court stuff, you got U.S. Code, CFR, federal rules, all these federal rules. You got the appellate, the civil, criminal, rules of evidence, and bankruptcy. And then here's that Uniform Commercial Code. And then law by jurisdiction. This is one you kind of want to pay attention to here. You got state law, uniform laws, federal law, and world law. But for right now, I want to take you to exactly what Christopher Hallett talks about. How he did his, here's Article 1, Section 9, limits on the legislative power of the federal. And we're going to go in there. And then we're going to go to Clause 8. Right here. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept any present emolument, office, or title of any kind, whatever, from any king, prince, or wow, they reworded that. They used to say title of nobility there. And emolument used to be afterwards. Weird. Section 10, title of nobility, that's to the states. So, you know, there's another one too that's missing there. Where's the bills of attainder? Okay, in Section 10 to the states is there's no bill of attainder, but I don't see any bill of attainder there at on the federal, and I know it was there. See, this is why I have these kinds of things, because then I can go double check. I'm like, wait a minute, because I've been on here plenty of times. I know that should be there.
Strikes back.
No title, yeah. Section 9, Clause 8, right here out of my book says, no title of nobility shall be granted by the United States. No person holding any office or profit of trust under them shall, without the consent of Congress, accept any present emolument, office, or title of any kind, whatever, from any king, prince, or state. Where's the bills of attainder? Oh, that's clause number 3. Okay. That's weird. Yeah, no bill of attainder or ex post facto law shall be passed. So this is part of, you know, the fraud type stuff that we talk about. These bills of attainder. Bills of attainder is legislation that describes punishment. That's color of law in our realm of things, because bills of attainders, you know, I mean, it's in the Declaration of Independence as a declared act of tyranny. That's why they wrote it into the Constitution here the way they did, that no state shall do anything with bills of attainder, pass any bill of attainder. So statutory law is basically all bills of attainder if they're trying to apply it to us, we the people. So what we call color of law, it's prohibited right here. So I want to go back and show you some really cool things about this particular website, where here it talks about explanation. You click on those there, and it takes you to the annotated Constitution. So here's one that I want to show you. Here you go. The 6th Amendment. Let's go over here, because this is pretty crazy. This takes you to the annotated Constitution. I'll take you to the right to a speedy trial.
Right.
Source and rationale. The right to a speedy trial may be derived from a provision of the Magna Carta, and it was a right so interpreted by Coke. That would be Lord Coke. This is a footnote, number 12. You scroll down here. Here's your footnote. We will sell to no man. We will not deny or defer to any man either justice or right. That's from chapter 40 of the 1215 Magna Carta, a portion of the chapter 29 of the 1225 reissue. And the case that it was referenced is Cloffer versus North Carolina. So the next one we want to look at, into the Virginia Declaration of Rights of 1776. And the reason why this is so important and why I'm showing this to you is because this is our lineage. And this particular document, Virginia Declaration of Rights, happens to be, when we lay down the law, because that's what declarations do, is they lay down the law. And in this particular instance, it's our ideology. And I have another little special tab here, if I can get to it, right? Come on. All right, I'm going to go over here. Now, this is one of my other favorite sites, avalonlaw.yale.edu. These are all sorts of documents, and these are some of the ones that I've been reading. So let's go find that Virginia Declaration of Rights. And I'm going into the 18th century documents, 1700, 1799. I'm going to scroll down here. And we're going to go, there's the Declaration of Independence. There's the Declaration of the Causes and Necessity of Taking Up Arms, July 6, 1775. That happens to be, where the Second Amendment actually is placed down as the law and the reasons why we took up arms. Where is? All right, where's the Virginia Declaration of Rights? Maybe it's down here in the V.
I'm going to reel you back in and back you up to the declarations part of this. And kind of one of the things that started this was before I petitioned Congress to enact E-clause, I had to obviously fight them as the monopoly, or bilateral monopoly is actually what they were. And this went in on 11:52 a.m. in, let's see, it was a 2017, and the exact month and date is right over top of the covering of my amicus brief, which was my reply to their reply. Well, on page 14 of that, and remember, that also was addressed to Congress under citizen petitions. So this is me walking into Congress, doing what Kirk just said, making a declaration. And my declaration was for a vote of no confidence in the bar. Now, why was that important? The importance and significance behind that is we said, look, based on all of these things that we've been doing since the 1700s, that we have established a relationship of trust, okay, which is where antitrust law comes from. And I was able to definitively show that I had been through the entire alphabet soup, been through the courts, been through everywhere with no relief or remedy of any kind. And because every one of these agencies said go to court, the only other thing I could do was say, okay, well, I did what you said. Okay, I followed your orders as you wrote them. And still with no relief and remedy, I walked back into Congress, and here's what I told them. I made a declaration for a vote of no confidence. Herein, and by full authority and standing, as the only advocate, as the only advocate for the people in this matter to make this formal declaration. Now, this matter was me versus Ohio. Within this 115th Congress of the United States of America, through proceedings and evidence, bring forth the current legal monopoly has become hostile to its intended purpose and breached its statutory duty to this republic. A redefinition and replacement of this entity has become necessary to ensure the continuation of this republic, the Declaration of Independence, and the Constitution of the United States remains intact. Therefore, I, Christopher Edward Hallett, born United States citizen, current resident of the state of Florida, Marion County, city of Ocala, hereby exercise my full authority and move for a vote of no confidence against the current practice of law, legal monopoly, also known as the bar. Under Article 4, Section 4 of the Constitution, see estoppel by conduct for details of the redefinition in relationship of the practice of law to the people. So when I drew the lines, that's the significance of where I drew on my knowledge and experience through my fiduciary practice and said, look, we've been doing this for a long time. Just because y'all didn't see it, you missed the parallel there. My dad calls it, we went through puberty and we didn't even realize it. It's one of my favorite jokes. And we've been working with fiduciary practices just when it comes to transactions, occurrences, or events for more than 100 years. And it's very efficient. It's very effective. And we can usually close a deal within 30 days. So they said, okay, show us what you got, kid. I said, okay. Went and did that's where Mr. Altenhofen and I got together. And we walked in March, I believe it was March of 2017. And by May had cleared his name. So I said, okay, go back to my appellate brief where I said, speedy trial implies speedy due process. Look, here it is, speedy due process. This can be done.
Right. Without sale, denial, and delay.
Serious. So, and that's basically the succession of how E-Clause, where it started, its infancy, and how it came to being. So that, I would hope, answer a couple of the questions that I keep getting about where, what is it? Where did it come from? Et cetera, et cetera, et cetera. How does a brokerage work? That kind of thing. So that's to try to answer that question. So anyway, go ahead and continue with where you were. I just wanted to answer that.
So just a quick recap here. We'll go back to what I was reading there is how the right to a speedy trial is how its lineage is. Okay, so the first part of the lineage was the Magna Carta into the Virginia Declaration of Rights, which is where I'm taking you right now. That's over here. And before I read that Section 8 there, Article 8 of the Virginia Declaration of Rights, we'll back up over here to number 4, that no man or set of men are entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services, I'm being blocked by mine here, which not being descendable, neither ought the offices of magistrate, legislator, or judge be hereditary. Imagine that. So we'll go back up there, back down here to number 8. Because this is where that right to speedy trial comes from, right? It passes through here. But what else passes through right here? And that in all capital or criminal prosecutions, a man hath the right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor. We call that denial of exculpatory evidence if they deny it. And to a speedy trial by an impartial jury of his vicinage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, that no man be deprived of his liberty except by the law of the land or the judgment of his peers. Now, what is law of the land? We talk about the Constitution being the supreme law of the land. The Constitution for the state is the law of the land. And where will you find the law of the land? You'll find the law of the land in your Bill of Rights. And just so we're all aware, and I can show that right here too, oh, I forgot to plug in my USB. American Jurisprudence.
Can I jump in real quick?
Sure, John, go ahead.
So going back to Section 4 of that, and this is also in our federal Constitution, right, Chris, about the separate emoluments or privileges from the community, right?
Correct.
Yep.
So just to give the audience an example of what's out there, and if you're taking a case federal, how to strengthen your case. Don't just go in there and say, this bad actor did me wrong and he violated my rights, because that's not appealable to go to the circuit court, and certainly not to the Supreme Court. They're just gonna say, oh, error. We don't care about error. We want to hear about big issues. So to go back to that Section 4 there, here in Tennessee, and this is very common across other states, is they've enacted statutes that are unconstitutional under Article 1, Section 9, the Emoluments Clause, or maybe the other way around. But so here in Tennessee, they enacted a law, and they said if you sue a judge in his personal capacity and he wins the case, then you have to pay him attorney fees. They don't do that.
Right.
They don't do that for everybody else. That's a special privilege. Wouldn't you agree, Chris?
Sorry, I had my mic muted. Yes, it is a
Yes.
a special privilege.
And so when you go into federal court, you say it's these special privileges that removes deterrent from them from violating the law. And that law is harmful to me. Not only is it unconstitutional, but it caused me harm by removing deterrent from him. And so you challenge these unconstitutional laws, and there are a lot. In Tennessee, I found at least 6 that are repugnant to the Constitution. And so, if you guys want to go and take your case federal, that's a really great way to strengthen your case, is to challenge unconstitutional statutes.
That's right. And you see, when you look at your state constitution, it talks about the integrity of the seat, the inherited emolument, okay? And basically kind of the long and the short of it is I said, okay, well, let's just remove the modifier and let's talk about the advantage, profit, or gain received in one's office, employment or holding of office. In other words, if you work in government, you receive emolument. Your paycheck is an emolument. So the significance of this is because nobody's ever questioned it. As now we're coming up to, well, what kind of other things do they trade? Well, let's see. They trade political favors. They trade judicial favors. They trade in all of these things, and they trade it like it's currency. Hey, you do this for me, I'm going to call in a favor and blah, blah, blah. And that's where the corruption starts. So, and, we already knew this. It just didn't become bad enough to go actually after it and say, okay, we need to do a complete read and review here and see where did the wheels come off of the wagon. That's kind of my favorite thing. So as I went through and I did what it is I do and realized what was happening, basically kind of the long and the short of it, it was just about every word in the Declaration of Independence, which is why in my judicial report, that's not appendixed. That is placed in the table of authorities. And because it is placed in the table of authorities, it's not just an attachment like, oh, here's a picture in a case or a piece of evidence, okay? The fact that that is the authority, that is the document that we're talking about when we're having this conversation. Right. So again, when we're talking about where it comes from, our Declaration of Independence, this is me telling them, look, this stuff that you have claimed that was going to be going to assist in the establishment, support, and management of government, you're reverse practicing this crap, and you're trying to apply it to us as the people, we the people. That first 3 words of the preamble in the Constitution. So we'll skip right over the Articles of Confederation. Let's just stick to these 2 for now. And That's why you saw that thing. The Declaration of Independence is a very, very powerful weapon, but it needs to be used and used properly. And that's where the fiduciary practice came in. As I said, look, not only do I know what this thing is, and I know it's a weapon, and I know how to use it properly. So it was like, oh God. And the more that became evident was when we walked into the Utah case, and we pointed out right where every integrity of the process issue was, from the start to right where we were at that point. Didn't miss a beat. So much so to the point we actually were defending Crystal's ex, and talk about not being able to wrap your head around that. So here's this poor federal judge who was a prosecutor, and she's sitting there listening to us say all of these things that are wrong. And as a prosecutor, because that's what she did before she was a judge, she knew we were correct. Right. So this is like where we did the old Houston, you got a problem. And it wasn't us being disrespectful or mean and vengeful of any way. This was us just saying, see this thing, see this problem right here? Here's where it comes from. Here's how we know it. Here's why we know it. And what are we going to do to fix it? So I gave a suggestion in that report, same as I did in my case. We equalize the practice of law.
Can I answer? Oh, sorry.
Yeah. And by doing that, we afford these attorneys or practitioners a due process, because right now under the bar, they don't have one. It's you piss me off and you're fired. That's it. There's no due process. You're either good or you're fired. And no in between. No in between. And that's a problem. That makes them hostile. It would make me hostile, which is why I never became an attorney. And believe me, I've been asked. I've been asked by some of the largest firms in the country. Dude, we'll pay for it. I'm sure you will, but guess what? I ain't doing it. So
how about you come underneath my license and my corporation and come work for me? Come work for E-Clause, and you start practicing real law.
Yeah, because your rules are not law, which of course again was an error that I pointed out. Well, that by the way, private corporation.
I want to teach people that that's actually what it is, because right here, American Jurisprudence, second edition Constitutional Law, Section 100. This is Volume 16. You can go down to your law library and pull this volume right off the bookshelf. This is the August 2017 update, so it's August of 2017, about as close as you're going to get. I think there's a February 2018 update now, but I got this here just this few months ago. So Section 100, generally, what we're talking about here is construction of the constitutions, construction to determine operative effect, specifically as self-executing or not self-executing. In general, let's talk about this. A constitution is usually a declaration of principles of the fundamental law, many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. Imagine that. However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing, that is, operative without any necessity for further legislation. Now, this is a part we need to understand about our ideology and our Declaration of Independence and this Virginia Declaration of Rights, because the Virginia Declaration of Rights is the theoretical foundation of all government. That's laying down the law of our ideology. When you read that, you'll see what I'm saying. Criteria which may be relevant in determining whether a constitutional provision is self-executing or not include a description of the right in detail, such as the means for its enjoyment and protection, the absence of any directive to the legislature for further action, a particularly informative legislative history as the revision's intended operation, and a consistency of self-execution with the scheme of rights established in the Constitution as a whole, right? So here's the observation. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills, plural, bills of rights, and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct. So, bills of rights are merely declaratory of the common law, right? Is that what that says right there? Okay, and they're self-executing. So the Second Amendment, where it says the right of the people to keep and bear arms shall not be infringed, that is a strict self-executing right in our Bill of Rights. Okay, and there is no delegation of authority to create legislation there. Right there. A clear distinction exists between the questions of whether constitutional revision is mandatory or directory, and whether it is self-executing or requires legislation in order to give it effect. I think where it says shall not be infringed, I'm pretty sure that that is a mandatory thing, that we all have the right to keep and bear arms, and it shall not be infringed. We look up the term infringe, that's, you know what it means, right? It can't be touched. There's right there. It's self-executing. We do not need legislation to give it effect. Go back to what Trump's saying and Jeff Sessions is saying, is that, the law says what it says as it is written. That's what the Second Amendment says, as it is written. Now, the first part is there, which everybody tries to claim, at least those that want to try and infringe on the right of us to keep and bear arms, shall not be infringed. They say, oh, well, that's only if you're in the militia. That's only if you're in the militia. Well, you kind of have to understand our ideology and our form of government here and our style of government.
We are all the militia, all the time.
Yeah, we're self-governed. So that's, we're a republic, Article 4, Section 4. Guaranteed Republican form of government. That's the responsibility of the federal government, is to make sure that the states are acting within a Republican form of government, a republic where we are self-governed. Now here's another one. Let's go back to this one over here. Let's see if I can get back over there. Come on. In the Virginia Declaration of Rights,
Hey, Kirk, while you're looking at that, can we jump over to Jeff Campbell's question?
What's his question?
He's asking what happens when someone wants to press charges on these guys compared to an average Joe. He was asking you that question, Chris.
Well, basically what I've done is I take through the Department of State. Now, remember, for lack of a better expression, my boss is the Inspector General. Okay. At the federal level, that's Rex Tillerson. He's the Secretary of State. So when I make a report, it goes to his desk. And I said, okay, look, here's where we are. Here's what's happened, right? We don't need to go into a court and confirm it. It's already happened. There's no denying. So, again, that's the significance of making a fiduciary report instead of making an allegation. An allegation is, oh, Chris came over and punched me in the mouth. Okay, prove that. And they have to prove that. This is based on what we already know, the habeas corpus, which Kirk talked about last week. That's why these reports are written in pretty much a habeas format, which they recognize and understand. Why? Because it's government. So I wrote out a habeas report and submitted it through my boss. And they looked at it and they said, yeah, all of these things are true. Every bit of it. There is nothing denying it. Every bit of this is it's verifiable. The authority is the Declaration of Independence. Wait, mock trials. That's in the Declaration of Independence. What did he say on page 1? And, so, it was, there's the significance behind it. So when you want to make a report and file your habeas, this is why I've been telling as many people as I can, go through your inspector general directly to your congressional oversight, judicial oversight committee. Why? Because these bar members are doing everything they can to hide the record. So the oversight committee cannot provide oversight. Remember Jason Chaffetz's frustration when he was asking the FBI for copies of their guidance documents. And these little attorney weasels were standing there giving them 75 reasons as to why they weren't ready to provide copies of the documents. He was so pissed he was ready to come off of that chair and strangle that guy. I mean, what was it, 1864 or something when that oversight committee was created? So anyway, it's been since the 1800s that we've been providing oversight. So, basically don't tell Congress that we don't have oversight, because Congress has oversight. We are the management, right? And if you don't tell us what we need to know to manage it, it's going to get swept under the rug. So I found this missing piece to do that. Report directly to congressional committees and give them the information that they have been begging for, literally begging for it. So,
and let me give you a different spin. So to go back to Jeff Campbell's question, what happens when someone wants to press charges on these guys compared to an average Joe? And so when you say these guys, I think you're talking about bad actors, judges, and
right,
professionals, and their cadre of people who violate our rights.
Correct. Well, that authority comes from Congress. That's what's called an impeachment process.
And I'm going to give you a specific example of the difference between when the state goes after a bad actor or when an average Joe goes after a bad actor. In Tennessee, we had a judge, Casey Moreland. This last summer, he was caught on video from an FBI agent bribing a police officer to plant drugs on a witness who was going to testify against this judge. And so the FBI arrested him. They had clear evidence. It was witness tampering. And they called him in, and like within the next day or 2 days, there was an evidentiary hearing, scheduling hearing, and they moved forward in that case against the judge. He was immediately removed from the bench. I presented facts of witness tampering, subpoena evasion, and extortion under color of law, and the district court made every attempt to deny me due process and dismiss my case. So when you proceed as an average Joe against these guys, they're going to work hard against you. But I promise you, if you follow the rules, you can defeat them in these kind of cases. You just have to say, hey, here's the rules that you guys made. I'm following them. I want an evidentiary hearing. Here's the rules that you made. I want a temporary restraining order issued, so on and so forth. And they will use every trick possible. Just one really quick example. They will almost always assign the case to a magistrate judge. A magistrate judge cannot issue dispositive orders. They can't make rulings. They can't dismiss your case. But they'll make a recommendation to the district court judge. Now, here's the trick. In the Federal Rules of Civil Procedure, if you do not object to a report and recommendation from a magistrate within 14 days, then you can't appeal it. You go to when the district court judge accepts that ruling by the magistrate, and you have not objected to it yet, then you go to the Court of Appeals. You file your notice of appeal. You go to the Court of Appeals, and they're going to say, well, you can't skip the appellate process. You should have objected. You should have taken it to the district court judge first. You can't skip the district court judge and come to us. So we're going to throw dismissal. Knowing the rules and that 14-day requirement is how you defeat them. It's how you keep your case alive and keep moving forward. And then, like I said earlier, add in unconstitutional statutes to strengthen the appealability of your issue to the Supreme Court and to the circuit courts. So hope that answered your question and kind of filled in on what Chris said.
Right. And what John's talking about in the court system is absolutely true. Now, in my particular case, I only had one issue, which was an audit that I conducted. And I said, this is what we're here to talk about, this thing. The rest of this crap, I can't change it. You can't change it. I don't even want to talk about it. I want to talk about this one item. And like John said, it was, backing and forth and arguing and the Rooker-Feldman this and, some, ridiculous, stupid argument that. I said, you know what? This is over when I say it's over. And I said it's over. So I said, look, been to court, been everywhere, and now we're going to follow the rules of Congress, which I know. And I know them. I know the rules of Congress like John knows the rules of the court. And when it comes to how to navigate Congress, it's the same exact mechanism as same thought process as the court. So when you walk in and cite, I am here under rule blah, 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 okay? They know, the clerk knows right where to take that document and which committee it goes to. So whereas my judicial report went to the Judicial Oversight Committee, my amicus brief went in under citizen petitions. So in other words, I don't care what committee you go to, this is going to get to the floor whether you like it or not. And that's the significance in the difference of the two. The declaration I wanted on the floor, the evidence contained in the case, I wanted done through committee because the Ohio Congress was not providing oversight. They were not impeaching that judge. So I said, okay, you don't want to do it? I can handle that. And I went above their head. Right. And that's kind of that's one of the reasons why I've been having so much success. And I got my company because they said, yeah, I mean, you can only round robin a person so many times before they say, you know what, enough is enough. We're done. This is not speedy trial or speedy due process in any way. 10 years is a bit excessive. So that's why I just said the hell with the courts.
Kind of like pulled us way off track of what I want to stay away from on the Monday night shows is this is about teaching the law on Monday night.
Right.
See, now everything that I've done has all been kind of broken up. And so it's kind of hard to remember where we were at and where we left off. But talking about the government itself, back to the Virginia Declaration of Rights, that government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, of all the various modes and forms of government that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration. And that whenever any government shall be found inadequate or contrary, so this will kind of answer your question here, Jeff, to these purposes, a majority of the community hath the indubitable, unalienable, and indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal. And we go to number 5, because that was number 3, that the legislative and executive powers of the state should be separate and distinct from the judicative, okay, and that the members of the two first may be restrained from oppression by feeling and participating the burthens of the people, they should, at fixed periods, be reduced to a private station, return into that body from which they were originally taken, and the vacancies be supplied by frequent, certain, and regular elections, in which all or any part of the former members to be again eligible or ineligible as the law shall direct. That's indicating that every single one of them is supposed to be elected.
And I would point out, Kirk, that section, that an unalienable, indefeasible right to alter, reform, or abolish is almost in every state constitution Bill of Rights. And that's the fundamental concept in my case that I'm taking to the Supreme Court is, I have a right to do it. It's unalienable, it's indefeasible. I have a right to do it. There's clear need for reform.
Right. And so that's kind of, this right here, Virginia Declaration of Rights is our ideology. If you understand, what I put out there before is the Law of Nations written by Vattel. He started in 1714, I believe, and went through like 1770, somewhere in there. So understanding how you create a nation, this document right here is one of the laying down the law and declaring our ideology.
And much of that is incorporated into
principles,
the constitutions.
Fundamental principles of law. You have to understand how the law of the nation, and this is how you create your nation. You have to declare your nation by laying down the law. This is the law. I know that it says Virginia Declaration of Rights, but if you actually understand our history, Virginia was the largest state, and this is actually written in the Second Continental Congress. Okay, this is everybody followed Virginia at that time because that's where Jamestown, Virginia, was the establishment in 1608. This is where everything was born out of, created from Virginia. So that's why Virginia is the one that says, which is right here in my Annals of America, doesn't show that on this website here, but right here it says that it's the theoretical foundation of all government. That's ideology. And the reason why it's ideology, and I explain it right here in the very last one, the 16th article, that religion or the duty which we owe to our Creator and the manner of discharging it can be directed by reason and conviction, not by force or violence. Okay? And therefore, all men are equally entitled to the free exercise of religion according to the dictates of conscience. Okay? And that it is a mutual duty of all to practice Christian forbearance, love, and charity towards each other. You don't have to practice the religion because that's your freedom of choice. Okay? Free exercise of religion. You're free to not exercise religion, but you're not free from the duties of the morals and principles of Christianity, which is the Holy Bible. This is where it's laid down in the law, in our ideology, where our morals and fundamental principles of law come from. That's the law right there. So, I guess I wanted to kind of jump around, I guess, a little bit into like showing the rules of procedure. Because when you're being subjected to these declared acts of tyranny, you have to know how to defend yourself. And I'm trying to show you what your rights are. And then now I want to show you, like what John was saying, if you follow the rules of procedure, you can beat them, and you can beat them bad. And the reason why is because even in their own rules of procedure, if you don't follow the rules of procedure and use their terms, you're speaking a foreign language to them. But the thing is it's the loophole for them that you're not doing your duty in reading the rules of procedure and how to effectively defend your rights. So I'm going to take you in here, And I'm going to go, let's go to Idaho Rules of Family Law Procedure. This is all something that you can do in your own state. Go to your rules of procedure and you read these rules. Okay. So the number one thing, if you're on the, obviously on the respondent side or the defendant side, let's see, we'll go in down here. I think it's.
And just a little history on why these rules were created. Much of the purpose is to make less what we can do for ourselves that we need an attorney. That's why they created these rules, was to establish a monopoly. So if you're going to represent yourself and stand up for your rights, because chances are if your rights are getting trounced on in court, your attorney isn't representing you. He's representing the interest of the court and the bar. And so, I think it makes sense to represent yourself when that starts happening. And and because they set up these barriers with these rules, you got to learn the rules that Kirk's giving you an example of.
And I mean, I have the argument pretty much down to where these rules I'm showing you right now, this rules of procedure, this isn't law. And this only applies to the agents of the agencies, because we at the common law does parental rights, okay, marital rights and parental rights are actually at the common law, which means we go back to where we were at there, Article 1, Section 9 and Section 10, bills of attainder. Bills of attainder are prohibited. Okay, that's legislation. It applies to the legislation. Applies to the agents. We're not allowed to the agencies at their jurisdiction because we didn't give our consent. We go back to the 7th article of the Bill of Rights, or 7th Amendment. It's actually the 7th article of the Bill of Rights. Suits at the common law. Okay, we're supposed to have common law courts here, and our rights are merely declaratory of the common law. Okay. So the common law is the proper jurisdiction, which is where we're self-governed. We, the people, at the common law, have our own courts, and we deal with our private matters privately, outside of government. We're not letting government interfere with our lives and our private lives. We live at the common law. And again, the common law is ruthless. Trust me, it is. I mean, you break the law, you could be screwed really hardcore. So instead of having the government do it and attorneying the people and making these charging instruments because of all this constructive fraud with the birth certificate, your social security number, your driver's license, your bank account numbers, all of that's all constructive fraud. It's fraud. So That's my argument. It's gone. Bye. Prove it.
That's an unlawful attornment, right? It's subversion of process, usurpation of law. So there's the design.
This right here, what I'm showing you right now, these rules of procedure, this is a jurisdiction that's unlawfully created.
Correct.
Because the right through substantive due process, kind of like due process of law, except for the part is, well, what are you talking about here? Well, we're talking about parental rights. Well, where do we find parental rights? Oh, we find parental rights are protected by the 9th Amendment. So that means it's other rights retained by the people. Oh, wait, Declaration of Independence, because it says that they're unalienable rights in my Idaho code. So the only place that we have unalienable or unalienable rights written in law, as it was laid down, is in the Declaration of Independence. Whoa, wait a minute. That means it comes from the common law. That means government doesn't have any jurisdiction over the common law. That's something that is rights that are retained to the people. Okay, not only the 9th Amendment, but the 10th Amendment, the 10th article of the Bill of Rights. The powers delegated here that are not delegated to the states are reserved, right? No, nor prohibited here are reserved to the states respectively, or to the people. So let's talk about what the or to the people is. Because there's got to be something that was left to the people, right? I mean, we didn't just give up everything to government. That's not what we instituted government for.
Right.
Declaration of Independence. What did we institute government for? for the protection of our rights.
Correct. So when we talk about, you know, what are the core concepts of where our law comes from and the ideology, like Kirk said, okay, we're also talking about now what are the core concepts and where does our practice come from? Okay, what's the language? Well, that's Latin, the language of the court, and is basically the loose translation of this particular maxim of law is where man-made laws fail, the law of nature must be used. Well, guess what? Family court is a major fail.
It's an Article 1 court. We didn't grant them the power to create an inferior court.
Right.
An Article 1 court to subject our rights at the common law into
our law.
admiralty or administrative court. And this is a piece of the puzzle I got with Chris the other night. He spent a couple hours with me explaining the negative nexus, and I explained some military tribunal that I went through when I was in the Marine Corps. And after I got off the phone with him there, I was sitting there thinking, I'm like, well, I could have had a V8. I get it. Okay. It's an administrative process using the equity scale. So it is admiralty jurisdiction, and they're using the equity scale because that's what admiralty law does. Admiralty jurisdiction does. They use the equity scale. So the negative nexus, now I got that all plugged in, and I got it now. I'm working on some other formulas there, although it might be outlandish. But because I am good at math, sixth grade, I'd already finished pre-algebra. So
wait till you see the completed algorithm.
So understanding this, how to defend your rights here. The very first thing, and this is right here in my own Idaho Rules of Family Law Procedure, Rule 206, general or special appearance. You know, you keep hearing us talking about, oh, you got to do special appearance. Here it is, right here. General appearance, the voluntary appearance of a party or service of any pleading by the party, except as provided in section B, subsection B hereof, constitutes voluntary submission to the personal jurisdiction of the court. Whoa, wait a minute, what does that mean? Well, let me read. B, motion or special appearance to contest personal jurisdiction. A motion under Rule 502A, 2, 4, or 5, whether raised before or after judgment. Okay, so before or after judgment, let's just jump right to 502 real quick. I can jump right back. This is defenses and objections, when and how presented by pleading or motion for judgment on pleadings, when, how presented. The respondent shall serve a response within 20 days, wow, it used to be 21, after the service of summons upon the party, or which such longer period is provided by statute. Okay, a party served with a pleading stating a cross-claim against him shall serve a response thereto within 20 days after the service of the cross-claim upon the party. Cross-claims, what are cross-claims? Cross-claims is where you put your tort claims in. You violated the law, here it is. You've committed perjury. Well, perjury in the state of Idaho is 1 to 14 years prison time, and that means that's a felony. And in Title 18, subsection 62, what is it?
1621.
1621 says that's a $250,000 fine. That's damages. Okay.
No, it's actually a $2,000 fine in Title 18. Subordination of perjury under 1622 is another $2,000. So for each occurrence that's supported by the court, that's a $4,000 payout. So get your clicker out.
Right.
Every time you lie, get your clicker out. Just start.
Right. So after we just looked at that 502 through motions, whether raised before or after judgment, those ones can be raised before or after. Listen, personal jurisdiction cannot be. So listen up closely. This is the first thing you have to file. Okay. The joinder of other defenses in motion under Rule 502 do not constitute a voluntary appearance by the party under this rule. After a party files a motion under there, action taken by the party is responding to. The joinder of other defenses in motion under Rule 502 do not constitute a voluntary. Somebody's got their audio on. Party under this rule. After a party files a motion under there, action taken by the party is responding to. Does not constitute a voluntary appearance. Okay, if after the motion under Rule 502 is denied, the party pleads further and defends the action. Such further appearance in defense of the action will not constitute a voluntary appearance under this rule. The filing of a document entitled Special Appearance, which does not seek any relief but merely provides notice that the party is entering a special appearance to contest personal jurisdiction, does not constitute a voluntary appearance by the party under this rule. If the party files a motion under Rule 502 within 14 days after filing such document, or within such later time as the court permits. Okay, personal jurisdiction. This goes back to what we were just talking about there, is that the common law, the rights of substantive due process, okay, the right dictates the proper jurisdiction, not government. Government doesn't get to dictate jurisdictions. Okay, we're self-governed here. We're a republic. That's per the Declaration of Independence. That's how we laid down the law of our nation here. So we don't consent. We're objecting to that personal jurisdiction, that forum, and that process. Okay, so if you're being subjected to a process that's contrary to your rights, and the proper jurisdiction to hear those rights, which would be the common law when you're talking about marital rights or parental rights, or your right to life, liberty, and pursuit of happiness, okay? Because in the Declaration of Independence it says among these rights is life, liberty, and pursuit of happiness. That's why James Madison wrote the 9th Amendment the way that he wrote that, was so that, other rights are retained by the people. This isn't all inclusive here, and we're not giving all of our sovereignty to the government. Title 74 to the Idaho Code, subsection 201, the people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agency so created. So that tells you right there that we individually have sovereignty. Why? Because we have creator endowed rights at the common law. That's our private business, and that's supposed to be held at a hearing pursuant to the rules of the common law, not pursuant to the rules of procedure for statutory law. That's bills of attainder. I'm objecting to that personal jurisdiction because these rules don't apply to me. That's not the rules of the common law. The right dictates the proper jurisdiction, not the government. And being that I'm not bound by the Constitution of the United States of America, and I'm not bound by the Constitution for the state of Idaho, none of that applies to me. I live in the private, the common law. And you can go read Hale versus Henkel. I've put that stuff out there for a long time. So, I know about the whole, common law marriage has been abolished. Government can't abolish the common law. They just can't. And I'm not talking about the common law of England. I'm talking about American common law, like I just read from American jurisprudence, the science behind the law. Okay, bills of rights are merely declaratory of the common law, because the law of nature is the common law of our nation. So this is the first thing we have to do here, is read the rules of procedure and how to effectively defend your rights and claim your rights. Okay, well, I'm claiming my parental rights actually over here at the common law, and here it is telling me how to do it. And so what happens is you can basically force the judge, the magistrate, okay, back to Virginia Declaration of Rights, they're supposed to be amenable to the people. So when you say, I don't consent to that jurisdiction, I don't consent to these rules of procedure, you can force the judge to put on a different hat and switch to the common law, even though it's actually supposed to be held by the people in the, I'll tell you straight up, it's supposed to be at the post office. That's where the common law courts are supposed to be. We, the people, are supposed to be able to go down to the post office and go, we need to use the room, and we've got our own judge, and we've got our own jury, because like it says there, from our own vicinage, okay? And that's why we go to the 7th article of the Bill of Rights, or 7th Amendment, and they added the suits at the common law exceeding the value of $20. you have the right to a trial by jury as well. Okay, so understanding the common law hears both the criminal and civil together. They separated it in the constitutions for the states for a reason, so they could make more money, make more rules of procedure to give you the this idea that, oh, well, this is how we do it. This is how it's done. No, 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 no. That's administrative law. That's out on the high seas. That's on the military base, like what I went through in the Marine Corps. That's exactly what it was. Okay, we the people take care of private business at the common law. You got something? Oh, Chris, you're muted. You're muted, Chris.
Can I ask a quick question, Kirk?
Yeah, shoot, John.
So even following their rules and their rules of procedure, you know, I walk into court and this is in the state trial court, and I said, you know, here's what this rule says, and we're not following it. And their response is, you know, you don't know the law, you're not an attorney. And I'm like, well, you know, it's pretty clear the language of the rule. Here's what it says, you know, and we're not following that. So what would be the difference when I walk in there and say, you know, I'm contesting this personal jurisdiction, and they say, you don't know the law, we're going to do this our way, tough luck, you know, or motion denied. What do you do? Is that,
according to the law, we're supposed to break out arms and then freaking tell them no.
Chris, you're still muted. I don't hear Chris. Do you, Kirk?
No, I see him over there. I don't have him muted. I can mute him and then unmute him again.
So is that when you take it to federal court, Kirk?
What's that?
You know, when you say, hey, I'm contesting personal jurisdiction, and they say, you don't know the law, we're going to do it our way. Is that when you say, well, I guess I'll have to go ask a federal judge?
Yep, exactly. Technically, again, this is supposed to be heard at the common law. So if you actually had a common law grand jury set up, which is kind of the stuff that I was just putting out, everybody's like, oh, well, is that fake? Is that, you know, who knows what that stuff is? Well, I do, because I know how the common law is supposed to work. Common law grand juries is 25 people. Okay, 25 people come together and go, that is unlawful, Mr. Judge or Mr. Senator or Mr. some representative, Mr. or Mrs. Representative in government, because all political power is inherent in the people. Okay? All of it, every last bit of it is inherent in the people. And this is where the confusion is between a republic and a democracy. We're not a democracy, we're a republic. Read Article 4, Section 4 of the Constitution of the United States of America. We are a republic, not a democracy. Nowhere in any of this will you find the word democracy. Nowhere. Because we're not. We might do some things democratically, like voting our representatives in, but that doesn't make us a democracy. We're a constitutional republic because the Constitution is ordained and established, and the republic is actually declared in the Declaration of Independence. It's laid down as the law, because that's what law means. You read Black's Law Dictionary. Law is that which is laid down, ordained, and established. So, Zoom group chat. Oh, Ted's doing something over there. Probably trying to get him back in. I don't know. Let me see. Let me exit screen share and pull us back in here, see if that fixes anything. No audio. Oh, wow. Zoom is totally different now. Weird. So, I mean, there's you know, trying to show you the rules of procedure. Getting your rules of procedure, you can like what John's saying, you know, but what do we do right there? Okay, this is when that creates that right to a cause of action to go to federal court. And with what Chris is doing and what Chris has done, there's a new process now. Now, you don't actually have to go through E-Clause and through us at E-Clause to do this, because it's already kind of set up through the Department of Justice. There's a link here that I could wrong.
Is Chris
I
trying
wish
to
I
follow
could
us
hear
now?
Plug your microphone in. Oh, you know what? I bet you did an update again and you lost your audio.
Department of
Yeah,
State.
Department of State or State Department. Yeah, but you know, they Department of Justice has put out a link to their stuff, and it used to be, you know, back before Trump got in there and started really banging this stuff out and changing stuff and doing the audit of the entire executive branch. It used to have the form right online where you could just fill it out and put it right in there. Okay, well, now the way they're wanting you to do it is actually download. It's a PDF. You can go in, download it, and you know, it asks you specific questions. It kind of lines it all out for you. All you got to do is put your information in there. And what Jeff Sessions said clear back in November or December, well, it was, yeah, I think it was November. Yeah, is file this complaint with the Department of Justice, and they will. Yeah, I know that was November 16th was the guidance documents. I'm talking about the Department of Justice, which I don't know, it may have been at the same time. It could have been. He was talking about human rights violations and human trafficking and stuff. And he said, okay, everybody who files a complaint, it will get investigated. Now, essentially, it's the same process that E-Clause is going to do, except for E-Clause helps with the Title 42 stuff going to, and this is where it gets split. This is the same thing. You can still go to the federal court for the civil rights violations, except for the tort claims goes over here to the Department of State or State Department. It's Department of State, State Department. You know, this is the new process because the way the executive order came out, okay, we're going to seize your assets for human rights violations and human trafficking. Now, human trafficking isn't always just the sexual side of things. That's the first section of human trafficking. The second part is turning you into a debt slave. That social security number, those charging instruments, you know, you've been attained to pay this bill, bills of attainder, creating those charging instruments and taking you into criminal court or even the civil court. They create bonds. As soon as somebody files a petition, there's a bond created. So they all get paid. And guess who? Whoever loses, that comes out of your trust fund that's created under your birth certificate and your social security number. The number on the back of your social security card is actually your account number for your trust account. So that's the charging instruments, and they discharge the debt, but they don't tell you they can discharge the debt. And so what they say is, oh, well, I guess you got to go to jail and spend some time in jail that's turning you into a debt slave. Because in reality, the way our style of government is set up, we're not supposed to be having people go to jail. Not unless it's a capital offense or a high crime, you know, piracy, felonies. Repugnant, yes. It is repugnant to our style of government. It's foreign to our form of government. It's a declared act of tyranny, right in the Declaration of Independence. All we got to do is read this stuff, guys. So, Chris, got anything to add to that? Oh, John?
I'll fill you guys in on another project I started on. So I just filed in the Tennessee Supreme Court. You know, everybody that's gone through this, perjury is a huge problem, right? And the courts just don't enforce it. Why don't they enforce perjury? Kirk, you got an idea?
Run that by me again. I was actually reading.
the courts like perjury because then the person, the victim of the perjury, has to come back and prove the perjury is false, right? And it's all about generating billable hours. So judges and attorneys love perjury because then they can make false rulings that's going to force the other person to come back and fight for their rights. They love it. It's
now,
like,
see, here's the part that we miss, okay? And when you have an attorney, they don't do this part. It's called cross claims, what I was just talking about reading in the rules of procedure there. I've been through all of my paperwork. I've never seen one cross claim. Cross claims are the tort claims.
well, I'm not talking about, perjury or fraud in the complaint. I'm talking about during proceedings.
That's what I'm talking about. Okay, so in the pleadings, like this temporary protection order thing I got, okay, in there she makes all these false statements. That's perjury, okay? So in my response, I have to claim my affirmative defenses, make my counterclaims, and that's usually what all the attorneys will do. But if you do the cross claims are, this is perjury, this is perjury, this is perjury, this is falsified evidence. Those are all the crimes. Those are called tort claims. Right there on the spot. And you'll see it here in my paperwork shortly. You list all of those tort claims in there. Perjury in the state of Idaho, Title 18, blah, 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 is 1 to 14 years prison time. That means that's a felony. So we go to Title 18, subsection 1621, and felonies are $250,000 a pop. We're around 20-some perjured statements in her paperwork. So we're going to times 20 times that $250,000.
So that's a huge learning point for me, and I hope the listeners out there caught on to that, because from what I just learned just now, what I should have done is, when I noted that perjury, amended my complaint to say perjury occurred here, and this is my cross claim. Is that right, Kirk?
Yes.
So
the counterclaim is the petitioner's statement here says blah, 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 which is false. In fact, this is the truth. Then in the cross claim is saying that statement is perjury. I'm showing the reason why it's false. And I'll even supply, well, you can't supply the evidence for a negative. The sky is green. Well, how am I supposed to show evidence that the sky is not green?
Yeah. So I raised the issue in trial court. The trial court agreed with me, but no sanctioning, and still ruled based on the perjurer's testimony as a basis of opinion. And I raised that issue again in appellate court, and the appellate court does nothing about the perjury. So I took it to the Tennessee Supreme Court and said, and I asked them, does this lead to chaotic proceedings where any person can just walk in and lie, say whatever they want, and they can do it with impunity? And so I said, I'm asking them, don't you think that the court should enforce that? I mean, who better to enforce it than our courts, right? That's where it's happening. That's where that crime is happening.
Right.
And I'm a victim, of this perjury. Not just of the results of it, but there was an attempted crime to extort $188,000 out of me. And I beat that part of it, but other perjuries I didn't beat. And so I'm asking the Supreme Court, are we done enforcing perjury statutes now? I think it's a good question.
Yeah. So, Jessica said, if you can get them to provide the transcripts to prove perjury. No. You're not quite understanding. This is in your initial response. So when somebody files a petition against you in the pleadings, which I just read from Idaho Family Law Rules Procedure there, you have to do your affirmative defenses, your counterclaims, and then what you're in your counterclaims, you're saying that statement is false, or there are no facts and evidence to support that statement. Now that's what that is that's a crime of perjury. That's false statements. That's a crime. That comes in the cross claims. You're claiming that is a perjured statement, that there is no evidence to support that claim, therefore that is perjury. That goes in your cross claim. So now you become the moving party. It's like switching the roles. Okay, so yeah, where the wheels fall off on the first affidavit. That's right. So in making your pleadings, I mean, I could pull that back up so we can show that again. Right here. Whoops. I gotta go share screen. Share screen. I want to show this because this is the part that the attorneys don't do, because this ends a case like immediately. If you send in your cross.
They like the perjury.
Well, yeah, that's what you just said, is that's what continues the conflict, and to keep each party keeping their attorneys hired. So, you know, again, this kind of even goes back to the common law, where I said the common law is ruthless. Okay, this is what I mean. If you file your cross claim and you go in there and say that statement is false, in fact, in your cross or your counterclaim, now that is perjury in the counterclaim says, here's the crime. It's 1 to 14 years in the state of Idaho to commit the crime of perjury. Okay. Then we go to Title 18, 1621 of the United States Code to give the fine, because in my code it doesn't give the fine anymore, which is weird. And things have really changed recently. So let's pull this up here. And
do you have an example of a cross claim, Kirk?
Yes and no, because I don't have mine completely done, but I can show. What it kind of looks like. Maybe, because I'm on this computer. So here, we'll just do this. I have to share. How do I do that? Oh, that's right. I have to go like this. Share screen. We want to do this one. Okay, put you back over there. Okay, so comes now Kirk Lee Pendergrass, hereinafter referred to as respondent or father. Respondent responds to sworn petition protection order in the above captioned manner. Respondent denies all allegations of the petition pursuant to Idaho Rules of Civil Procedure 8B3 and demands strict proof of petitioner's claims. In other words, saying, yeah, it's a bunch of bullshit and I'm not buying it, and you're going to have to prove it. Oh, by the way, because I know that it's a bunch of bullshit, here's my affirmative defenses, and this is what affirmative defenses look like. Okay, petitioner fails to state a claim for which relief can be granted and should take nothing thereby, and her petition should be dismissed pursuant to Idaho Rule Civil Procedure 8C, motion for dismissal. Okay, this court lacks personal jurisdiction. A, respondent was not traveling in interstate or foreign commerce or any special maritime or territorial jurisdiction of the United States. Respondent does not consent to the form or process which deprives the respondent of the fundamental rights to substantive due process of law, and trial by jury. Okay, that's why you don't have personal jurisdiction here. Oh, Chris, probably come right back.
Yeah, he's been right back.
This court lacks subject matter jurisdiction. The public record reflects that a decree of divorce was granted to the parties on June 30th, yet the parties were never married. So that's fraud upon the court. And part of what this court's trying to claim was, well, there's this marriage contract. So that's what gives us subject matter jurisdiction. Nope, not in this case. And then there's other parts of the affirmative defenses. Assumption of risk. Petitioner has made several false claims against the respondent under penalty of perjury, which may or may not be under the advisement of her attorney, Douglas Levitt. Okay. I haven't finished with contributory or comparative responsibility yet. Duress. Petitioner's choice of law, and choice of jurisdiction was an error, which has deprived the father and child without due process of law of several fundamental, unalienable natural rights and civil rights protected by the 1st, 2nd, 4th, 5th, 6th, 7th, 8th, 9th, and 10th Amendments of the Bill of Rights, Declaration of Independence, Constitution of the State of Idaho, and the Constitution of the United States of America, with threats of use of force and violence or arrest if respondent exercised some of those rights. Estoppel. Okay. Let's see. The principle that precludes a person from asserting something contrary to what is implied by previous action or statement. Petitioner's claim that respondent was banned from daycare is false. In fact, the daycare lady had never filed a complaint against me. She seemed to think that parents don't have the absolute right to come in there. Okay, so here's where I'm talking about that in the protection order, that right on the frickin' protection order itself, this is the code they're talking about, interstate domestic violence. You go in there and you read it. Well, then it says, well, wait a minute. In this chapter, or this is what this is based off of, person who travels in interstate or foreign commerce or enters or leaves Indian County or is present within the special maritime and territorial jurisdiction of the United States with the intent to kill, injure, harass, or intimidate a spouse, intimidate partner or dating partner, and who, in the course of or as a result of such travel or presence, commits or attempts to commit a crime of violence against the spouse, intimate partner, or dating partner, shall be punished as provided in subsection B. Right there, on its face, in the clear and plain language of the statute that's on the protection order itself. Okay? That's lack of personal jurisdiction right there. Okay? And to further this, in the same chapter, based on this, okay, there's the stalking. This is all still. Whoever travels in interstate or foreign commerce or is present within the special maritime and territorial jurisdiction of the United States. Okay, I'm not in there, and that's up there in the affirmative defenses. Now we go to Title 18 U.S. Code, Chapter subsection 7. Special maritime and territorial jurisdiction of the United States defined. The term special maritime and territorial jurisdiction of the United States, as used in this title, includes the high seas, any other waters within the admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. Right there, in the clear and plain language, that is telling you out on the high seas, on the navigable waters, within the admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. Why? Because admiralty and maritime jurisdiction is out on the high seas, not here inside the states. That's a jurisdiction that was delegated to the federal government, not inside the states. You're supposed to protect us from that stuff, and that's what those powers delegated to Congress and our military to take care of. Okay? Any vessel registered, licensed, or enrolled under the laws of the United States and being on a voyage upon the waters of any Great Lakes or any of the waters connecting them, or upon the St. Lawrence River, where the same constitutes the international boundary line. Okay? So when you object to personal jurisdiction, oh shit, that's right, I closed this. When you object to the personal jurisdiction, oh man, how do I? When you object to the personal jurisdiction here, the other side is supposed to come in here and go, well, no, see, this is where we have jurisdiction here, and here. But see, they can't come in here and say that this is where it happened, because it specifically says it cannot happen out on the high seas, or it can't happen inside the borders of a state.
You know, I'm thinking about, I'm definitely filing another complaint in the federal court, probably within the next month or so, to deal with some more bad actors in the state. could I go in original jurisdiction under common law with that case?
I would think so.
And can I get around all of the BS 12B motions and the court's unwillingness to follow due process and say, now let's let a jury decide this thing and get around?
That's the way it's supposed to be.
I may test this. I may test this, Kirk.
This is. I know this is kind of an oxymoron. File in the federal court your federal lawsuit and then make a motion for dismissal for lack of personal jurisdiction.
Well, that's actually what I did in my lower court.
Well, I'm talking about going to what John was just talking about, going to federal court. And you know, we all know that I haven't personally been in federal court yet for filing a lawsuit per se. But when we do, we know, those of us that know this, what's the first thing that they file?
12B, motion to dismiss for lack of jurisdiction. So guess what we did? Yeah.
So right here is what we need to understand. That's what they do. And that's what I'm trying to teach you to do here is look in your rules of procedure and how to file that notice of special appearance objecting to the personal jurisdiction under the Rule 12B, and in family laws, it's 502. Okay? That's exactly what we need to do, the same damn thing.
Right. I just took the long way out.
Make them prove the jurisdiction, which was what I was showing on the screen there. There's no way they're going to be able to prove their jurisdiction, the personal jurisdiction, because I wasn't out on the navigable waters and blah, 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 blah. So let me go back to that. Let me go back to that because I wanted to get to the tort claim part and show people what that looks like. I haven't done the counter claims or the cross claims yet, but the way I have it set up, it will be. I'm just putting it all together.
So can you file into federal court and say this is a common law case?
I did that.
That's one way I would like to try and figure out. Okay, so here's the I put the annotated constitution in here. You know, right straight out of law.cornell.edu. Maritime law. Congress may implement the admiralty and maritime jurisdiction conferred upon the federal courts by revising and amending the maritime law that existed at the time the Constitution was adopted. But in so doing, it cannot go beyond the reach of that jurisdiction. 1681 is the Detroit Trust Company versus the Thomas Farland. Okay, that's the case number. Okay, you would quote there. This power cannot be delegated to the states. Hence, acts of Congress that purported to make state workmen's compensation laws applicable to maritime cases were held unconstitutional. Can't get any clearer than that. Okay? Now, here's my counterclaims. Get into the meat of some here. Okay. Petitioners claim that on January 20th that our son told her that he got in trouble at father's house for his disrespectful attitude is false. In fact, no such occurrence happened. Our son doesn't even know the meaning of those words, nor has the father ever heard him use big words like that. Okay, he's 3 years old, 3.5 years old. Further, in fact, father does not use spanking at all for discipline. In fact, father has only used timeout 3 times and hasn't had to use timeout for well over 6 months. Further, in fact, pursuant to Idaho Rules of Evidence, Rule 514A, C, and D, alleged statements are confidential and are not to have been disclosed, as well as Idaho Rules of Evidence, Rule 801, is hearsay and should be stricken from the record. Now, Idaho Code Section 185409, punishment for perjury. Perjury is punishable by imprisonment in the state prison not less than 1 or more than 14 years. Now, the other part here was going to be Title 18, Section 1621, $250,000 for that statement right there. That statement that she made is 1 count of perjury. Now, this is what actually goes into the cross claim. So 14 up to 14 years in prison between 1 and anything over 1 makes that a felony. Okay. So in Title 18 United States Code subsection 1621, you go in there and it says felonies, $250,000 in damages. That is what gets written in the cross claim. So the petitioner committed the crime of perjury by making this statement, and the punishment for perjury here in Idaho is Idaho Code 185409. And see, like I said, that's it right there. It just says perjury is punishable by imprisonment in the state prison not less than 1 or more than 14 years. There's no fine there. That's what I was telling you, Chris, the other day. Those fines all just disappeared out of my code.
You can expect that.
And that's what you were saying, because they've all been used. So,
right. Because guess what? When they finally figured out that's the stuff that we're using to manage them with, they're like, oh, we are in about a metric crap ton of trouble, right? So
yeah. So here's the second one. You know, it just, you go through your paperwork and you do a chronological order in your counterclaims. And so anytime that you can find something in there that's not factual, that you know that there's nothing in the, okay, I don't care if you know that it's true or not. If there's no facts and evidence to support that, that's what the first affirmative defense is about, is no, I'm not, because you have to affirm or deny. Okay, this is where we talk about if anything left unrebutted, okay, becomes truth and fact in the evidence, because when it goes to trial and you didn't rebut that or force them to produce the evidence, that's unrebutted, dude. You're screwed.
Yeah. It becomes
you gotta
fact.
do your paperwork.
If
You
an
have to go to court and you have to rebut this stuff, and you have to force them to produce the evidence to support your claims. If they don't do that, they get away with it. And that's what attorneys do.
If an attorney makes a false statement to the court, that's not perjury, is it?
No,
Oh,
it's
yes,
misconduct.
It's what?
Yeah, it's misconduct. It's misconduct that is classified under a 28 USC subsection 1927.
Yeah, I saw they actually, 1927, there's an exception clause that says an attorney representing a client that makes a false statement isn't subject to imprisonment.
Correct. And the reason is, for example, like in Kirk's case, we were just talking about, his ex comes out and makes the false statement. The attorney in that matter has no way of knowing if it's a false statement. He's only going by, on good faith, what she told him.
Translate versus Pagliaro.
If an attorney makes a knowingly false statement,
that's a different animal. If you can demonstrate that that statement was knowingly made false, that's a whole different animal.
This is where you have to be Johnny on the spot, and you say, objection, Your Honor. The attorney, Schmuckatelli over there, is attempting to enter facts in the record that's not in evidence.
Correct.
Well, Mr. Attorney, you got those facts and evidence over there? Well, no. Translate versus Pagliaro, Mr. Judge, Mr. Your Honor, there, if you're going to act honorably. While statements made by the attorneys may be enlightening to the court, they're not substantiated by facts and evidence.
Correct.
Is it anything beyond misconduct?
Well,
yeah, that's a crime.
As the question goes,
and then that goes back to their, well, not just Idaho, but Idaho Rules of Professional Code of Conduct for the attorneys.
Yeah, so it's just
on every circumstance and every case is a little different. So, for example, if the attorney lies and you end up in jail or prison or incarcerated in any way, that magnifies, right, the damage incurred by you as the victim of the crime, right? So basically what we have is we have prosecutors walking into court and lying to get a conviction that either does or does not involve incarceration. But because the whole thing is stapled to your rear end as a criminal record, that's the same as lifetime incarceration, or branding as we've called it, right? We said that you can't do. And they've said, yeah, you know what? You're right. We can't do that. So that's one of the reasons why we're starting to see legislation now about yanking the public records out, destroy them, because that branding is something they can't do.
Right. So Jessica, she's asked a couple questions here, and Ken Scott, you're saying some stuff here too. But let's talk to Jessica here for a second, because she's talking about. Let me go back. About suppressing evidence. Okay, that's a motion. Motion to suppress evidence, whether if it was illegally obtained. So it's the exclusionary rule. Fruits of a poisonous tree. If they seized your phone or whatever, or they made false statements. So if it's some sort of state actor like a social worker, CPS, or whatever have you, you can go to a motion to suppress and say, where's your evidence to support your claim here, Miss Social Worker, Mr. Social Worker? Well, I'm just saying. So, well, that's not pursuant to the rules of evidence. That's called hearsay. You don't have any firsthand knowledge that happened, and you don't have any evidence to support your claim. So, Judge, motion to suppress.
Now the other side, and I don't know how the context of her question, but it may also be that the court is suppressing your evidence and not allowing you to permit it. And if they do that wrongfully, then that's witness tampering.
Well, it's denial to make your defense, like I was just reading there in the Virginia Declaration of Rights. It's part of the Sixth Amendment. You have the right to confront the witnesses against you. You have the right to enter evidence in for your defense. That's a right at the common law. Okay? So, and the way to get your evidence in there is through this paperwork right here. Okay, that also goes into the cross claims. Okay, I'm going to claim that, yeah, she did hit me with a car door on the 13th. Here's my evidence. I have an audio recording. I have a firsthand knowledge witness, the neighbor across the street who watched the whole darn thing. He wrote out a witness report. I wrote out a witness report and an affidavit. I went to the hospital. I had medical records to prove it. This is all going into evidence. Now, when we go back to court, that's going to support my cross claims that she committed the crimes.
Yeah. No,
and that right there is punishable, okay? Because that's battery.
Well, I was talking about another common practice that you see in the courts is you'll subpoena a witness. And you'll say, I want to subpoena this person to trial because they have testimony the court should hear. And then the attorney and the judge will collude, and they'll say, no, we're going to quash that subpoena. That's witness tampering. They're preventing they're unlawfully preventing testimony into your case. And under that same witness tampering is also preventing somebody from providing evidence to the court. Also falls under that. So if you have judges and lawyers colluding, not allowing you.
That's denial of exculpatory evidence.
Here's the one thing you can't forget. Now, this is where we talk about the element of practice, and everybody, including myself for a long time, missed it. When you file in your cross claim, you need to file a specific separate document that you're moving the court to transfer from Article 1 to Article 3 proceeding. You do not consent to Article 1, you will consent to an Article 3. And after that is when you file your cross claim. And here's the reason that's significant that you do that beforehand. Because if you do it, if you get and you move to Article 3 proceedings, you have just applied the common law in that case. If they deny it, that is an appealable offense.
See, and that's why I go back to the notice of special appearance is the first thing you have to do. That's where I was going back to what I was doing there. That's what you're doing is you're objecting to their admiralty jurisdiction, and you're forcing the judge to put that other hat on, and we go by the rules of common law.
But you have to call it what it is.
But you have to, right. You have to do it in the very beginning.
No, you can do it at any time.
Consent and proceed under the rules of the common law, because that's
you can move to Article 3 proceedings at any moment. You can move to Article 3 proceeding at any moment.
That's right. That judge can take off that administrative hat, admiralty jurisdiction hat, and lean over and pick up the common law hat and put that sucker right on.
That's the big wig with all the white curls and shit in.
It's that simple. You know, people think, oh, well, we have to go to a different courthouse and technically, yes, if we're actually going to operate in the common law, because that doesn't have anything to do with government in and of itself. And again, I can take you right here to American Jurisprudence, Volume 15, Civil Rights Section 2, that says natural rights, civil rights have nothing to do with the establishment, support, or management of the government. Because our rights are supposed to be taken care of in the private. We instituted government to protect our rights from foreign and domestic invasion.
I'm going back through some of the comments here. This just to confirm, because we're seeing, like Jeff says, can we use citizens arrest on their asses? No.
Yes.
And just for the sake of right now, with everything being the way that it is, don't do anything stupid.
I was just going to say.
Because basically follow the rules of workman's comp. Workman's comp doesn't cover stupidity. So kind of the long and the short of that is, if that's one of the reasons why you go through and you say, look, this jurisdiction, like Kirk's talking about, the Admiralty jurisdiction, I'm not wearing my my military uniform. You, sir, don't look like you're wearing military uniform. We are not out on the high seas, so guess what? Right now, I'm moving this to an Article 3 court, which is the common law of the land.
Mm-hmm.
And by doing that, you're basically stipulating, okay? You're saying, look, we can talk about this here today if you go and we're following the common law. If we're not following the common law, I'm not talking, and I'm objecting to Article 1 proceeding, as that doesn't even apply here. We're not talking about a boat. We're talking about a kid, whole different animal. So that said, if we're not going to move to Article 3 proceeding, here is my notice of appeal. Have it ready and drop it on them right then and there.
I'm so ready to just do writ of habeas corpus.
Well, you do the writ of habeas later on, but in order to shut them down, right, which is kind of the goal right now, look,
That's
you're either
okay.
we're going to proceed under Article 3, which means you can't interfere in my parental rights, or we're going to shut this down. Them's your choices, because you want to talk about money. Hey, here's the bank statements. Here's what it is. Signed off on by accountant ABC accounting firm. There you go.
I'm going to throw a monkey in your wrench, because where does an Article 3 court come from?
Say that again.
Where does an Article 3 court come from?
Well, you can consent to an Article 3 proceeding.
No. Does an Article 3, you're talking about the Constitution of the United States of America, right?
Right.
Article 3?
Right.
Okay. That's in the Constitution. The
Right.
common law courts are over here. Two separate jurisdictions.
Exactly my point.
Delegate to them. So in essence, the court that you're in literally lacks all jurisdiction. That man up there. But if you want to try to do that, you're probably not going to be very successful. So that's why it's better to move it to an Article 3 court.
Right.
At law.
Right. That's why I said move to Article 3 proceeding. If they're willing to do that and you can get in and get out, hey, path of least resistance.
Right.
But
again, I think maybe you're missing what I'm saying. Where is the common law court supposed to be at?
In the big courthouse with the flag with no fringe on it. Or
no.
in the
Common law courts are at the post office. That's our court.
Well, again, like I said, choose your battles, right?
Right. That's what I was saying. If you can get them to go, reading my Constitution, Idaho Constitution, I'm okay with that as long as I have my trial by jury, and I will make the specification right back to the Virginia Declaration of Rights. If you're not going to take away my parental rights and deprive me of my son without a trial by jury and without whose unanimous consent to find me guilty.
Correct.
I will not consent to anything else as it is written.
Right. So that's why I stipulate, right? Because remember, in Article 1 proceeding, they're going to give you an order. You can say, well, I'll agree to this, but under the stipulation that, right? That you can say. Okay. Mm-hmm. So you're going to say, okay, well, I'm going to agree to this room under the stipulation that we're going to follow Article 3 rules. So that's the trade-off, right?
Yep.
And, put your big ugly wig on, Judge, because it's going to get hairy from here. And by the way, now here's my cross-claim and evidence. Here's my sui juris. Here is, here's my habeas. Here's the appendix. And, next thing you know, you've got a rainforest sitting right there on the clerk in front of the clerk, and the clerk's going, what just happened here, dude? Can I dismiss this? Absolutely. Bye. We're out of here.
Yep. And this stuff works in the criminal courts, the traffic courts especially, because that's a straight up bill of attainder. Saying, okay, I want a trial by jury. Oh, well, sorry. Well, I'm appearing specially. That's the first thing you're going to say to begin. Well, do I have a right to a trial by jury? That's why I'm appearing specially, because I don't consent to that jurisdiction. And,
right.
That doesn't have any personal jurisdiction over me. So kick rocks. I'm not consenting to that.
Yeah.
If you want to use force and violence against me, we'll go back to our ideology. That's a big time no-no.
Exactly.
All right. So we are at 8:07.
They what?
8:07 my time. So 10:07 your time.
Yep. So anyway, I'm just going to filter through a couple of comments here and see if I can find anything that we want to.
Oh, yeah. There was something Ken had said.
Amen, Neely. I live in a free country because my Father in heaven said so. That's your.
Well, Ken, brother, I know what you're doing out there too, and I know. But what we need to understand is this is a new era. We have a new administration of government. This is a new process for us. This remedy, straight to the Department of Justice.
No, through the Department of State, right?
Well, yeah, but the form is on the Justice website.
Right. So if they're going to unlawfully administer justice under illegal attornments, right, we're going to take that administrative process and run their ass all through every one of them loop-de-loops, right? Why? That's what is just, right? That's what they're supposed to have to do.
We establish justice. That's in the preamble. We the people establish justice.
Correct.
We the people ensure domestic tranquility. That's why it's supposed to be at the common law.
Well, that's why I volunteered to do the job.
So, yeah, you don't have to necessarily go through E-clause to do this process, although it seems to be a lot more powerful. But I'm thinking you don't have to be E-clause. You can file this same thing with the Department of State.
Here's what I tell everybody when you're talking about. Remember, we were talking about what is a habeas? What does it look like? Right? I always tell everybody, go to your appellate court, state appellate or federal, either one. And there's two of them there. There's one for inmates and one for non-inmate. So whichever one applies to you, you can take, and every single piece that's required in that court's habeas format is right there. Mm-hmm. What each heading is, and it's clearly defined in the heading. So certificate of interested persons, for example, right? Well, who all has interest in this case, right? So you go down and you make a list. Officer John Jones from the Sunland Police Department. I have a police report with this guy. Obviously, whoever the attorneys were and the judge was, they were interested parties because, oh yeah, they participated in this. So, when it comes to how you compile your list of interested parties, just go down through and say, oh, yep, Mary Smith. I got this notice from Mary Smith from Department of Children and Families. She's now an interested party, right? And that's how you construct that part of the document. So And it's that exact same process. Just go down it. There's the title. What do I need to put there? There's the title. What do I need to put there? And it's very simple to do. You don't even need a template. All you need is a blank sheet of paper.
Yeah.
Seriously, write the heading on it and then write what goes there. Then go to the next page, write the heading and write what goes there.
The form, there's forms right here that I posted last week. Same thing, forms for the civil habeas corpus.
Right.
Download them, print them out, fill them out.
So when you read my reports, that's the reason they're formatted in a habeas format. That's written in law.
Mm-hmm. Now, they don't put a whole lot out there. I went and looked at the United States Code on the writ of habeas corpus. There's not a whole lot there at all.
Yeah.
So I did find that PDF on the history of writ of habeas corpus, which helps a lot because it breaks it down and says what the writ of habeas corpus is for. And you can actually quote stuff from that document.
Correct.
And writ of habeas corpus is if you're being deprived of your life in pursuit of happiness in any way, shape, or form without due process of law, you have a right to a writ of habeas corpus. And that is an ancient right. You don't have to be incarcerated. That's another one of those misnomer telling you that fraud has a statute of limitations. You're right. When we're talking about clerical errors and mistakes, yeah. But when we're talking about fraud in general, no, there's no statute of limitations.
To be intentionally misled in a court of law, no. Time out.
Constructive fraud, conspiracy to commit fraud,
denial of due process, denial of reasonable defense. Stop me if any of this sounds familiar. I mean, just saying, right? I mean, it is what it is. So,
writ of habeas corpus. I'll just go ahead and put that link up in there again.
Mm-hmm.
Oh, no.
Let me guess, you logged out.
No, I clicked on it on the page and I was watching the video. Hopefully that's still okay. Good.
Yeah, mine booted me. I'm gonna see if I can get back into it real quick.
Okay. AO 241, and that is 2254. Copy link address. Okay. Here's a petition for writ of habeas corpus, folks. Download it.
There it is. Is it working? Yay, it's working. Right.
Now, one is in state and the other one is in federal, but, most of us aren't in federal. So the first one, which is weird because when I post this one, man, it shows up real nice and puts the little thing on it.
Yep.
But the other one, it doesn't.
Well, and it's funny because when we talk about,
oh, well, it didn't do it on this one now.
Right. This is what I want people to know. I want them to know what their process is, right? When it comes to teaching the law and where it comes from, that's your strength. And as far as, how to follow that process, it's just as easy, right? And if you take the steps that are written and follow them clearly and concisely, and you're still denied, well, then you can say, okay, that's it, time out, we're done. And it's over when you say it's over, right? And you say, okay, look, on this date, here is the crime. Here is what transpired as a result of that crime, which only makes the crime more egregious, right? And, they've attempted to ravel me up in this ridiculous process that is repugnant. See Marbury versus Madison. Mm-hmm. And we're going to go all the way to Congress and say, here, Congress, here's my habeas, right? This due process that you guys wrote, it's not being followed. and here's the definitive proof of it. It's all in the record.
Hey, Ken, I know you said that form is for a person. No, that's not true. Just because that says on the form that it says it's for a person, the writ of habeas corpus is an ancient right, and it has to do for the man. If you read up on writ of habeas corpus, I don't care what the words on that form say. Writ of habeas corpus is for a man who has had his rights deprived without due process of law, not person, because writ of habeas corpus came long before the Constitution of the United States was created,
Correct.
Long before the bankruptcy in 1871 and 1933, okay?
Correct.
Long before all that. That's why it's an ancient right. And it's
Right.
written
So if
into the
they're telling you that they're telling you that, no, you can't do that, that's a usurpation.
That's
right?
trickery.
That's an example. That's confidence trickery from a confidence man, right? That's all of the same shit that we're talking about. All of it.
Right, Ken. I know that that's what it says on the form itself, but when you get into the actual writ of habeas corpus part, it doesn't say anything about person. So what you can do is you can actually wipe all that crap, and you can actually build your own writ of habeas corpus by going off of the format, and you can shorten that form way up, because it's almost like every other form. You got to put your name, your location, all that good fancy stuff, and that shortens everything. Oh yes, there is another case pending on this, and this is the case number.
Right.
Those are vital information that you have to put in there on everything.
Right. So
Because
for example,
reference.
the certificate of interested persons. Some of you may have 200 people. Some of you may have 7. It's just, every one is a little different. As long as you have the pieces there, you're golden.
Yeah, I wish you could drop a file, Ken. I'm not sure if you're in Kirk's Law Corner group or in Amber and Steven.
He is. He's in Amber's group.
Okay, if you're in Amber and Steven, Ken, go drop a file in the files section in Amber and Steven if you got a file to drop. And while you're in there, look for that writ of habeas corpus document that I put in there, because that gives the history on it and why the right is the way it is. The right itself, as it is in law, as it is written. I don't care what that form says for a person and da-da-da-da-da. The right dictates the law, not that form. All right, thanks, Ken. On that note, gentlemen, thank you, John, for joining us tonight, Christopher Hallett, and welcome back, Ted. Really appreciate you. I had no real stress tonight. I didn't have to fumble around and go between 3 devices. And
that's why we love
to watch this over here. I was able to focus on and actually do some teaching tonight. So,
yep.
Thank you, my brothers and sisters out there. We love you. Thanks for your support. One thing I did want to share there is go into the following tab in Kirk's Law Corner. And if you'll notice, it says unfollow this page. No, I'm just kidding. First, instead of on default, so you actually will get a notification when we go live. Not only that, I'm going to try and set this up as events, and we're going to try and go live through the events on Wednesday. We're going to try that. And Wednesday is going to be the call-in show. So it's all going to be pretty much about you. So if you got questions for us, you really want to come in here and share, and hopefully Nate is going to be on Wednesday.
Probably not till Monday.
Okay.
Because remember that stuff that we're going through, we just dropped in over 1,400 pages on the Office of Inspector General, today. So.
Oh, geez.
Yeah. So when he walked in and had his little coffee cup in hand and sat down and saw sitting there, he's going, oh, shit. So he's got some reading to do this week, and I'm sure he's reading it because it's an ongoing matter. And so I said, keep your eyes on Texas this week, folks. It's going to be, everything's big in Texas. Put my hat on.
There's some stuff going on down in
That's
Texas.
the one right there, baby. That's the one. So
thank you for tuning in. Thank you for sharing. Like, share.
Love you guys. Yep, Ken, I'm going to try to get out that way tomorrow. I got nothing on the books. I kind of got suckered into that policy meeting today. What a pain in the ass that was. So,
Is that with
anyway.
Florida, Chris?
Huh?
Is that with Florida or work?
What? Policy meeting?
Yeah.
Florida. That was here in Ocala. So, yeah, good meeting though. We got a lot done. So, I think there's probably going to be some vacancies in the agency. Oh, well.
Gonna make some cold seats over there, huh?
Hey, quit spending that government money if we don't have to spend it, right? That's our tax dollars. That's where we need clean water, roads and bridges, et cetera, stuff that we can use, right? A decent power grid.
Yeah.
So,
yeah, right.
Hey, it is what it is, man.
Proper plumbing. How about cleaning up some of the water, like in Flint, Michigan?
Yeah,
I'm okay here in Idaho, but Flint, Michigan's got some problems over there. So
I know they need to drop a filter in that sucker. I mean, just
That reminds me, some of the water down there was in the Marine Corps.
That must be where the swamp drains into, is that lake, man.
I'm sorry, Flint, Michigan.
Had me on your
The
Zoom,
folks of Flint, Michigan.
Yeah.
I pray that our president and your local representatives, whatever, can do something about your water. That's disgusting. Not right.
Yeah, amen to that. So, on that note, ladies and gentlemen, have a wonderful night, and we will see you guys with the next update.
See you Wednesday. Much love, friends, brothers, and sisters.
Amen.
All right. You're fired.
Judson.